Reverse discrimination. When will we make an end? Maybe this term of the Supreme Court. Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yesterday, the Supreme Court of the United States heard argument in two classic cases of racial discrimination in university admissions. The arguments showed plainly that the universities involved have no case at all. Their defenses amounted to, we obey orders, said orders being existing Supreme Court precedents. Well, you know the line. An argument that didn't work for Lieutenant William Calley, United States Army at My Lai, and an argument that didn't work for 19 very high-profile military tribunal defendants in a city called Nuremberg. But the argument session also showed the remaining ideological corruption that will continue to plague this court unless and until Congress finds the courage to remove members of the judiciary from the bench on impeachment for and conviction of infidelity to the Constitution and to its founding principles. Before we dive into these two cases, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, especially this t-shirt that I have chosen for today, which quotes Ronald Reagan as saying, "If fascism ever comes to America, it will come in the name of liberalism," which it did. And the banshee screams that attended the 2021 term of the court also sounded outside the courthouse yesterday as the court heard oral argument in these two cases. One more thing. If you like what you are about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, did you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click on that and leave me a tip. Any currency will do. And now, oyez, oyez, oyez! The Supreme Court of the United States of America held argument on October 31st, 2022 on two cases. So here begins a tale of two universities, two lawsuits, and one common question. Students for fair admissions brought suit against two universities alleging racial discrimination in admissions. The two universities are one each public and private university. We have the University of North Carolina system and Harvard University. I have links in the description to docket entries, argument transcripts, and argument audio files for both these cases. Why two cases? In fact, the court consolidated these two cases at first, but the court then deconsolidated them for two reasons. First, the cases present two questions each, but present only one question in common. That question is whether the court should overrule a certain precedent allowing for racial discrimination in whole or in part. In addition, UNC as a public university system must obey the Equal Protection Clause of the Constitution. That doesn't apply to Harvard, which is a private university and always has been. For Harvard, it's Title VI of the Civil Rights Act. Second, Justice Ketanji Brown Jackson was once associated with Harvard. Therefore, she must recuse or disqualify herself from taking any part in the Harvard case. The common question in both cases concerns the precedent of Grutter versus Bollinger, 539 U.S. 306, 2003. I have a link in the description to the summary page of that case at oyez.com. No, that's oyez.org, I should say. Barbara Grutter, white, applied for admission to University of Michigan Law School. Her whiteness knocked her out of the box. She sued and lost. Justice Sandra Day O'Connor delivered the opinion of a sharply divided court. Here's the summary. In a 5-4 opinion delivered by Justice Sandra Day O'Connor, the court held that the Equal Protection Clause does not prohibit the law school's narrowly tailored use of race in admissions decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. The court reasoned that because the law school conducts highly individualized review of each applicant, no acceptance or rejection is based automatically on a variable such as race, and that this process ensures that all factors that may contribute to diversity are meaningfully considered alongside race. Justice O'Connor wrote, quote, "In the context of its individualized inquiry into the possible diversity contributions of all applicants, the law school's race-conscious admissions program does not unduly harm non-minority applicants," close quote. The 5 were O'Connor, Stevens, Souter, Ginsburg, and Breyer J.J. The 4 dissenters were Rehnquist C.J. and Kennedy, Scalia, and Thomas J.J. Since then, the composition of the court has radically changed. In place of Stevens and Ginsburg J.J., we have Alito and Barrett J.J. Those 2 substitutions change the ideological balance of the court. The other substitutions don't matter. Roberts for Rehnquist, Kavanaugh for Kennedy, Kagan for O'Connor, Sotomayor for Souter, Gorsuch for Scalia, and especially Jackson for Breyer. Thomas, in fact, is the one holdover from the Grutter court. This then sets the background for the 5 hours of argument that took place yesterday, October 31st. Now, reportage on the argument day comes from the New York Times and the Daily Signal. In addition, we have the argument transcripts themselves in the UNC and Harvard cases, and the court also makes available downloadable sound recordings of the UNC and Harvard arguments. Again, I remind you, I have links in the description to both transcripts and both recordings. You really should play the recordings. Tone of voice is at least as important as the dry words. The 2 lawyers for petitioners, Students for Fair Admissions, open with a direct appeal to Brown versus Topeka Board of Education. That was clever of them. Open with the very case with which Thomas J. would have the greatest sympathy. They also point out that neither school argues that they must make up for any discrimination in the larger society or at the institution. That's one argument they cannot make, though Kagan, Sotomayor, and for UNC, Jackson try to make it for them. Their bottom line, racial classifications are simply wrong on their face. Furthermore, the information available to the universities is incomplete and unreliable. The application form for admission includes a checkbox question. What is your race? A student may answer, or not, as he wishes. And besides, no one checks that answer out for truthfulness later. I'm going to recite for you one doozy of a Q&A session between Justice Samuel A. Alito and Mr. Ryan Y. Park, Solicitor General for North Carolina. But first, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting gold and silver and other precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. And now, remain seated and come to order. Court is again in session, and here's this Q&A session. Justice Alito forced the Solicitor General of North Carolina to admit that the criteria for racial identification are fearfully lax. Here is how that session went after I resolved the occasional crosstalk between those two men. Question: when can a student honestly claim to fall within one of these groups that is awarded a plus factor? So let's say the student has one grandparent who falls within that class. Can the student claim to be a member of an underrepresented minority? Answer: yes. We rely on self-reporting. Key phrase, self-reporting. And we don't give any question, all right? One great-grandparent. Answer: if that person believes that that is the accurate expression of their identity, I don't think there would be any problem. Question: one great-great-grandparent? Are you going to make me continue to go on? Answer: right. I think that as we go on, I agree that it would seem less plausible that that person would feel that this is actually capturing their true racial identity. But the same is true for any of the other diversity factors that we rely on. Question: it's family lore that we have an ancestor who was an American Indian. Answer: so I think in that particular instance, it would be not accurate for them to say based on question: well, I identify as an American Indian because I've always been told that some ancestor back in the old days was an American Indian. Answer: yes, so I think that in that circumstance, it would be very unlikely that that person was telling the truth. And the same is true for, we rely on self-reporting for all the demographic and other characteristics that we ask for. And there's nothing special about the racial identification on that score, Your Honor. Isn't there? Is this not the heart of the matter? Can the legal departments of UNC or Harvard really be naive enough to assume that applicants always tell the truth? Doesn't the recent college admissions scandal tell them otherwise? Now, I don't need the recent history of Operation Varsity Blues in 2019 to tell me that. When I matriculated at Yale College in 1976, so did another student who came with glowing recommendations attesting to his academic ability and rich life experience. Before we broke for Christmas, that student was out of Yale. His entire record was fraudulent from beginning to end. The administration discovered the fraud by the oldest method they had. He couldn't do the work. Besides, we know of one famous person who did rely on family lore to score points. Senator Elizabeth Warren of Massachusetts, Pocahontas herself. Now, all these cases tell us that students will check off anything to try to get in. And as Alito further pointed out, college admissions is a zero-sum game. Colleges and universities have only so many slots available. Absolutely any institution of elementary, secondary, or higher education must limit admissions by reason of availability of space. And that goes double for a place like Harvard, where that kind of space is at a premium. So, to make space for members of one group deserving of social justice, you have to shove others aside. Why do you think the Boston Globe started calling Senator Warren Pocahontas? And why did that name stick? Because she lied about her Cherokee affiliation to score political points. And by the way, the Cherokee Nation has repudiated her self-identification. Surely Jackson, Kagan, and Sotomayor J.J. know that. That should tell them that racial distinctions are pointless. A point Thomas J. understands. But they do not. Worse, Justice Sotomayor definitely tried to assert a fact not in evidence for which she laid no foundation. She argued in the Harvard case that de jure discrimination still occurred. discrimination Harvard is in honor bound to remedy. Alito and Gorsuch both called her on that. Alito also asked, when does it end? The SFFA lawyer in the UNC case brought up, in fact, that the Grutter majority contemplated an eventual end. Both UNC and Harvard argue that they have the power to discriminate in perpetuity. And don't think you can sneak that past this court. Thomas was there, and I have no doubt that he remembers. And Justice Jackson in the UNC case questioned whether the Asian students who lost out at UNC could claim any injury in fact. She reasoned that UNC, like Harvard, looks at the whole person. But she and her colleagues miss 3 points. 1. Race cannot be an adequate proxy for adversity as an explanation of poor prior academic performance. 2. The Constitution guarantees individual justice, not group justice. 3. College admissions committees must concern themselves with predictors of academic performance. They do members of underrepresented groups no favors if they admit students who later flunk out, like that student at Yale who got in on a fraudulent basis. If they want to affect the larger society, they have to make sure those students graduate. And if they fudge graduation requirements, future employers will know. And that will harm all who graduate from the institutions involved. The tone of the questions of the 9 justices, 8 in the Harvard case, predicts that the court will likely rule 6-3 or 5-3 in the Harvard case in favor of the petitioners. Decades of reverse discrimination will end. The time to ensure educational opportunity starts during childhood, to prepare the future student to do college work. This also assumes that any student would benefit from a college education. Not all prospective students would, but those who would should not face discrimination as a punishment for some real or imagined crime that in any case they did not commit. Link in the description of the article to the docket entries, argument transcripts, and argument audio for those 2 cases, to the summary sheet for Grutter versus Bollinger, to my new Declaration of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to oursilverlines.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to my channel, and I'm going to leave links to maybe a few other Supreme Court cases, at least from the 21 term, or one other discussion when I knew that students for fair admissions, those 2 cases were going to come up way back in the beginning of summer. This is Terry A. Hurlbut delivering another Declaration of Truth and reminding you to let the truth set you free. Did I say 5-3 in the Harvard case? I meant 6-2 because Jackson won't be there. Okay, everything else will serve.